A lot of contested trust administration proceedings don't begin with misconduct, they begin with silence. The trustee isn't communicating properly with the beneficiaries or maybe even with you, the attorney. Qualified beneficiaries are entitled to information, and that information is they're entitled to know of the trust's existence. They're entitled to know most of the time of the settlor of the trust. They are entitled to know who the trustee is. Beneficiaries have a lot more rights than some trustees and potentially even some advisors who really understand and know.
Welcome and thank you all for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Tarina Stid. Tarina Stid spent over 15 years in private practice working in AM Law Top 100 and 200 firms, mid-sized firms, and boutiques. When the opportunity to join the American Academy of Estate Planning Attorneys, the quote-unquote academy, presented itself, she jumped at it. The Academy is an organization dedicated to empowering attorneys from around the country to fulfill their potential through its tested systems, procedures, and workflows. Tarina knew that her broad range of practical experience would be invaluable in her role as the Director of Education at the Academy. Tarina spends her days helping member firms resolve issues ranging from how best to structure an estate plan to determining which sections of the Internal Revenue Code will apply to a particular transaction to administering estates and trusts efficiently. The webinar presentation that you're about to watch will be approximately 1 hour, and time permitting, Tarina will be taking questions from the audience at the end of the presentation. You could submit your questions for Tarina by clicking the Q&A button in your control panel, and if you have any questions for me throughout the presentation, you may also submit them there. Now, without further ado, here is Tarina to discuss Trust Administration Unleashed, Advanced Issues, Fiduciary Duties, and Practical Pitfalls. Take it away, Tarina.
Thank you, Nina. As always, oops, there we go. I was frozen for a second. Sorry, everybody. Thank you for that wonderful introduction. And I have to be honest, I'm going to share with you that this is my absolute favorite presentation that I give. Full stop. I love talking about trust administration, and talking about it unleashed means that we get to dive into the meatier topics. We're going to skip over those beginning topics. Of course, I'll set foundations wherever necessary, but really and truly, I think I've lost track of the amount of times I've given this presentation. And every time I kind of remember something new or tell better stories, and it always brings a smile because this is really truly where I lived when I was in private practice. So without further ado, we are going to jump right in. You will note there are a lot of slides. I probably won't get through all of them, but I share them with all of you, and I welcome any feedback, suggestions for betterment, etc. I hope that you find something new and exciting about the wonderful world of trust administration. So let's set the stage. This is where the rubber meets the road. We have spent time learning how to draft. Now someone has died, and we have to make sure that the document itself can withstand the administration, how the document behaves in the real world. So the question becomes, what pitfalls do we need to be looking out for, both in our conversations with our trustees and within conversations with beneficiaries, if that's who we're representing? So this is it. This is where it all comes to fruition and where things can very quickly go off the rails if we are not keeping a tight leash on what's happening with the trust and with our trustee. So first and foremost, a lot of contested trust administration proceedings don't begin with misconduct, they begin with silence. The trustee isn't communicating properly with the beneficiaries or maybe even with you, the attorney who's representing them. And so this is where frustrations kind of start to build at the very beginning. So maybe the beneficiaries haven't received a timeline for administration. Maybe they just received a check in the mail with no explanation whatsoever. Not that they're sad about the check, but maybe they were expecting more and they don't understand why they've received a lesser amount. Maybe items are being sold and communication is not occurring. Or perhaps they're expecting accountings and they're not getting it. And so this idea of communication, I think, is really where it starts. Like, this is where, whenever I think about the trust administration litigation matters with which I was involved, at least one, if not multiples of these issues were what was going on. And so this is where we start. So communication, delays, the perception of I should be getting more, why am I not getting more? Or, hey, where's this? Where's that? And then also remember, emotions run very high. Somebody close to a beneficiary, and likely the trustee, has just died. And it could have been an unexpected death, or even if it was expected, it's a sad time. And so people are operating not at their calmest and best, but at that higher state. And so you want to keep that in mind as you think about and advise the client, be it the trustee or the beneficiary. Excuse me. Something that I talk about in both my probate and trust administration talks is this idea of it's a zero-sum game. So even when an administration goes the way that it should and everything goes perfectly, costs associated with trust administration can be high. There are trustee fees, there's attorney fees. They think that some clients think that just because they've avoided probate, the fees are all done, and that's not the case. Most of the time, the trustee has to employ the services of an attorney to help walk them through what it is that they need to do, and we'll talk about that a little bit later. And then if we add on any litigation, if any beneficiary sues, or if you have a beneficiary who is kind of the squeaky wheel, costs can escalate quickly. And so because those costs rise, that means at the end of the day, there's a smaller amount going to the beneficiaries. So no matter what, this is what I call a zero-sum game, because in order to do what's required pursuant to the terms of the document, we're still going to run up fees, which means the beneficiaries are going to get less at the end. So we just have that natural born tension that already exists before anything has happened and even when everything goes right. So just always keep that in mind. And then, of course, this idea of delays. When they happen, it only serves to increase fees. So the final piece that I just want you to keep in mind, so we're talking about these things, this communication, high running emotions, lack of documentation. These are all the things that cause friction to occur and just get worse and eventually could lead to litigation. So you want to keep all of that to a minimum. Remember too, and this is the list, we've got liquidity, creditor priority, tax liabilities, informal promises, blended family, and income versus remainder beneficiaries. These are other areas where contention, where friction occurs just because of what they are. So if there is any misalignment between the fiduciary and the beneficiaries with respect to any of these issues, that is another natural source for contention, and that's going to build mistrust and misalignment and could ultimately lead to litigation. So I'm not going to speak in depth about any of them here, but just these are the high level places where you want to be thinking about, if I don't tread carefully, this could lead to litigation. I need to advise my trustee appropriately when talking about these issues in particular. Okay, so let's talk about, where do we get our information? Where does the advice that we're giving come from? Well, the Uniform Trust Code is where it starts. So the Uniform Trust Code is made up of 11 different articles. I'm not going to go through the articles at length. You can read them on your own if you are so inclined. But the most important articles in my mind are Articles 7, 8, 9, and 10. And you'll notice that talks about the trustee, the duties and powers of the trustee, the Uniform Prudent Investor Act, and the liability of the trustee. This is where we really have to counsel our trustee carefully. And we, as the attorneys, as the counselors, need to make sure that we understand what our particular state says with respect to these things, because this is going to inform the trustee's actions. So 35 states as of March of this year, I have not double checked, but as of today, but as of March, when I sent this presentation in, 35 states had adopted the Uniform Trust Code. California, actually, the California the California Probate Code trust provisions serve as the basis for the Uniform Trust Code. The District of Columbia also follows the Uniform Trust Code. And then even in our Uniform Trust Code states, there's a similar setup. So everything that I talk about today is going to be applicable to you no matter where you practice. But you need to understand if you are a Uniform Trust Code state or a non-Uniform Trust Code state, and how your state addresses the various issues that get raised. But they all have uniform applicability across the nation. But this is where I'm deriving everything that I'm talking about today. So I think I like to always start with this idea of understanding what the trust instrument can do and can't do. Just because in theory something can't be done in the trust instrument doesn't mean that some attorney didn't try to do it. Put another way, there are certain things that no matter how good your drafting software is, no matter how good of a draftsperson you are, you cannot draft around. That is the mandatory rules for the trust and for the trustee and for information that needs to be conveyed to the beneficiaries. There are just certain things that are mandatory. It doesn't matter what the trust document says. You need to understand what those things are in your particular state. And on the flip side of that, what's discretionary? What are the things that you can insert in a trust document and actually kind of change provisions of the Uniform Trust Code applicable to your trustee and for your beneficiaries? So that's this whole idea of mandatory versus discretionary. Of course, I'm going to talk about what they are. So first, the duty to act in good faith is absolutely mandatory. You cannot waive the trustee's duty to act in good faith and in accordance with the purposes of the trust for the benefit of the beneficiaries. There's no way around that. Full stop. That is a non-waivable duty. The duty of loyalty. The trustee is not permitted to act in self-dealing, and the trustee cannot have a conflict of interest and act. And so, again, these are the things that cannot be waived. They are floors. They are the absolute bare minimum standards by which the trustee must abide. Full stop. That's it. They are the floors. Everything else is kind of window dressing and additional steps that they can take. The duty to inform and account, this is a major duty. And again, depending on what the laws of your state say, there might not necessarily be a duty to account, but there is absolutely a duty to inform. It is incumbent upon you as the practitioner to understand what exactly that entails. So, and this right here, this is the biggest, I think, litigation trigger out there. The failure to inform, the failure to properly inform the beneficiaries, not advise, because you might not be representing them. Well, you can, but different issue. Or your trustee. And so it's the duty to inform, potentially to account as well. Failure to do these and do these appropriately are really problematic. You'll note that under that, I've got some notes about qualified beneficiaries, the trust existence, the identity, the right to request reports, and then reasonable requests. And so what I mean by all of this is the provisions of the Uniform Trust Code and probably of your state's trust code say that qualified beneficiaries are entitled to information. And that information is they're entitled to know of the trust's existence. They're entitled to know most of the time of the settlor of the trust. They are entitled to know who the trustee is. They're entitled generally to know the address and contact information for the trustee. Oftentimes, they are also entitled to know who the attorney representing the trustee is. In addition, they are entitled to request reports. Most of the time, you, as in trustee or attorney advising the trustee, has the duty to advise them that they are entitled to request those reports. So they can't, it's not just that they're entitled to the reports, you need to make them aware of their right to request those reports. And then there's also, generally speaking, other reasonable requests about knowing what's going on with respect to the trusts. So they are allowed to know this information. Now, there are certain ways, and that we'll talk. Oh, good. I already put it on there. So, virtual representation allows the trustee to advise someone else and provide the information to another person um, who has the same or similar, I think is the language, but you'll want to make sure to double check your particular state statutes, the same or similar interest. So as long as the person who the trustee is informing has interests that are aligned with another beneficiary for whom they are representing, then they can advise that representative rather than the beneficiary themselves. However, you need to be extremely careful, number one, in making sure that your state actually recognizes this idea of virtual representation. And number two, that the individual chosen as the virtual representative does not have some sort of a conflict with the beneficiary whom they purport to represent. So it's a great idea in theory. There are certainly some hiccups in practice, and I just want to make you aware of them. Again, not an across the board thing, so you want to make sure that this is an acceptable practice in your state and that you have chosen an acceptable party to be the representative. One final note before we, nope, never mind, two notes before we move away from mandatory versus discretionary. So the court has a power to intervene, and they have that power to modify or terminate a trust under Section 410 of the Uniform Trust Code. They can require, dispense with, modify, or terminate a bond requirement under Section 702. They can adjust a trustee's compensation under 708 sub B, particularly when it's unreasonably low or unreasonably high. The court can also take such actions as might be necessary in the interest of justice. Don't ever forget that kind of catch-all. The court can step in if justice so requires. And so these are things, again, there are certain things that we can talk about and modify under the terms of the trust, but there are also certain things that are mandatory, and there are certain powers that the court always has, regardless of what we put in the trust itself. So if we have some exculpatory clauses in there, they might serve to insulate the trustee from liability, except in situations where there is bad faith or an outright breach of a fiduciary duty. So these are the things we want to just make sure that we are cognizant of in doling out the advice that we're giving, and that we are talking to our trustees in real time about what it is that they're doing and that their discretion isn't unlimited. We'll talk about that in a little bit. Okay. And then the last piece of the puzzle here, the requirements for a valid trust. So we can't draft around that. The trust has to have a lawful purpose, it has to have definite beneficiaries, and it has to be capable of administration. We can't have a trust without those things. And then there are certain specific sections that we often see. There are limits to spendthrift, for example. Even under a very well-drafted spendthrift clause, most states say if there is child support that's due, that the trust can be tapped to pay that. We're not going to allow funds to be held in a trust when somebody has a child support. So that's one of those situations where just because there's a spendthrift clause, it's not absolutely unlimited. And I'll talk a little bit more about that later. And then again, too, like I said a bit ago, this idea of exculpatory clauses, they exist, they can work, but they don't give this unlimited um, exculpation. They don't give no liability, especially when we have bad faith, reckless indifference, or breaches of our fiduciary duties. Okay, so to kind of tie this up all together, um, the litigation triggers. So remember, we started this by saying, okay, this failure to communication is big. If there is a perceived unfairness, and let's talk about that. So this perceived unfairness, that arises in a situation where we have income beneficiaries and remainder beneficiaries who are different. So let's say and it happens most commonly in a blended family situation. So let's say we have a settlor or a trustor, and he dies and he leaves a trust that says, okay, I want you to pay income to my wife for her life with the remainder to adult children from a prior marriage. This is very common in my home state and the state where I practiced, Florida. Happens all the time. I think it's fairly common in lots of other states as well. This is a very common scenario. The trust, let's assume that this trust holds about $3 million in low yield growth stocks. Well, this makes those remainder beneficiaries extraordinarily happy. However, it's not making the surviving spouse happy because these are low yield stocks. And so the wife comes to the trustee, her stepson, and she says, I need you to liquidate these stocks. I can't live. Your father, we had a certain lifestyle and I can't keep it up like this. And she's got no income. Well, of course, the children say, absolutely not. We want those growth stocks, which you already have. And so let's assume for our sake that the trustee liquidates everything, doesn't do like a halvesies or anything. The trustee says, all right, you know what, stepmom, you and I have always gotten along. That's why dad named me trustee. So I know that he loved you. I know that you were good to him. I know that he would want you to have the life that you had prior to his death. And so I'm going to go ahead and liquidate these stocks and I'm going to reinvest them. He gets sued by his siblings, and because he had a duty of impartiality, he cannot just favor that income beneficiary over those remainder beneficiaries. That's this perceived unfair. Well, that's not perceived unfairness, that's actual unfairness. But the idea here is he can't just do something like that without documenting it and without alerting the beneficiaries to what's happening. And so there is a power to adjust under the Uniform Principal and Income Act, and that's where that we use those powers to resolve this tension in some way. So that's something else I don't mention it a lot, but something else that you probably also should familiarize yourself with is the Uniform Principal and Income Act as it's adopted in your state and see what kind of tools exist there. I've talked about delayed distributions or the idea of what the beneficiaries see as incomplete distributions. And then finally, fees. This is another hotbed area for litigation. If the fees are thought to be too high, or if the trustee thinks that the fees are too low, there's going to be some friction and that could result in litigation. So again, this is not intended to be exhaustive out of all these areas. What it's really intended to do is alert you to some of the things that could be litigation triggers. And on that note, we're going to talk about why that is, because this is the area, like I said, this is my favorite presentation, full stop. And what I think what kind of always drew me to this area was this inherent tension that exists between the trustee, whoever that is, and the beneficiary. So let's pop to the next slide. So the trustee holds legal title to the assets, right? That's the only person who can deal with the assets. However, they're holding it in a fiduciary capacity. And so they need to administer the trust in the best interest of the beneficiaries and also in accordance with the terms of the trust. However, it's the beneficiaries who have the equitable title to those assets. So it's not like the trustee can just go off and do whatever they want. They have a duty, and it is a sacred duty. It is the highest duty in the law. Perhaps the only duty that's higher is our duty to keep client confidences, but this is the most sacrosanct duty in all of the law. Other than that, with respect to clients, beneficiaries, the trustee has a fiduciary duty to administer the trust for their benefit. Full stop. That's why the duty of self-dealing, that's why this idea of avoiding conflicts or even the appearance of conflicts is so important, because a fiduciary is held to a higher standard. The fiduciary has to do what they need to do pursuant to the terms of the trust in the interest of the beneficiaries. Think about how hard it is to actually do something that is in someone else's best interest all the time. It is extraordinarily difficult. It's not really human nature to always be selfless and to always put somebody's needs above your own, with certain exceptions. Parent-child is what I'm thinking, but even then it's hard. And so imagine now we're adults dealing with other adults. Well, not always, but see that idea, there's that inherent tension. So on this slide, I've listed the duties, the trustee and this overarching duty that the trustee needs to act in good faith, in accordance with the terms and purposes of the trust in the interests of the beneficiaries. That language is kind of imprinted in my mind and on my tongue, because that is the single best way to tell a fiduciary, trustee, you can't do this, and here's why. It is not in the best interest of the beneficiaries in accordance with the terms of the trust. Full stop. This is where really, literally where the rubber meets the road. So I've seen, so many issues with respect here. And so this is kind of that example that I was giving before about the income and remainder beneficiaries. That example perfectly highlights all these duties, and most importantly, the duty of impartiality. On the next slide, we've got additional duties that might crop up in your practice. I actually have another example that I'd like to discuss here. So remember that the power to direct exists in the Uniform Trust Code under Section 808. What that means in practice is that somebody else might be telling the trustee what to do. So that sort of could relieve the trustee of some of their potential liability if a trust director is the one telling them, I want you to do X, Y, or Z. But the trustee still has their own duties to satisfy. So we can't just say, well, I was doing what the trust director said, if they ultimately know that that is something that they shouldn't be doing, or if it's some sort of a conflict or an act of self-dealing. So we have to be careful about that. I put the duty to segregate property, the duty to enforce and defend claims, the duty to collect trust property and distribute assets expeditiously. They all kind of fall under those trustee duties, and there's more on the next pages as well. These are not, again, intended to be the end-all be-all, but what they are is a good place to start. So these are the duties that you must have a conversation with your trustees about, particularly the ones on the prior slide: loyalty, impartiality, prudent administration, control and protect trust property, incur only those costs that are reasonable. I made that note. Oh, I'm glad I went back. You can delegate. Your trustee has the ability to delegate to another individual with comparable or more advanced or specialized skills, for example, an attorney, a CPA, or a financial advisor. So the office of the trustee comes with the ability to delegate certain things. Be careful about that delegation. Okay. Trustee powers. So I put those on there again, but I want to spend just a touch of time talking about the duty to diversify that is found under the Prudent Investor Act. So the duty to diversify is inherent in your trustee's duties. What does that mean? What does that look like in real life for you? Well, here's a great example. So let's assume that a trust holds 80% of its value in a family, in a business that is the family's regional chain of hardware stores that was inherited from dad. These stores have been the primary source of income for the family for years and years and years. And the trustee, the eldest son, who is involved in the business, right, believes in the business and continues to hold the business for 5 years while operating on it. Unfortunately, because dad has died and dad was the real kind of emotional tie to the community, the business declines in value over those 5 years. And when the son finally decides to sell it, it's sold at a 60% loss. That is staggering. The remainder beneficiaries, in all likelihood his brothers and sisters, sue, alleging a breach of the duty to diversify. The trustee's defense is, hey, dad ran the business. Dad would have wanted us to keep it. That's not a legally defensible position. It might be true, but absent a clear direction in the document itself that says, keep this business together, I am waiving the duty to diversify, that's a problem for your trustee. So again, I'm not trying to say you need to sell the business right away. I'm saying if you're on the drafting side and the intent is to keep that business, make sure that you include language in your trust that says keep the business and or sell with it, put whatever parameters around it the client wants to insert, but make sure that that is very clear. And if your trustee is going to hold that concentrated position, document why very early and revisit annually. And even better, if the beneficiaries are involved in that decision and you have them sign acknowledgments or documents and are providing them with all the information so that they can make an informed decision. So just one of the myriad of ways that trustees meaning well can end up doing wrong. Okay, some of the other trustee issues, and again, I'm not going to spend much time because even right now I'm already a little bit behind the 8 ball, so I got to start talking a little faster, and for that I apologize. I just get excited about this stuff, and I have so many anecdotes that I can share. So make sure that you are aware that these are other issues. Accepting the office, that acting in certain ways can raise personal liability for your trustee. Make sure that there are issues if you have co-trustees that you are documenting who agrees with and who dissents from the opinion if they are constantly at odds. Hopefully there's a mechanism for resolving that. Understand what happens if there's a vacancy. What happens upon the resignation of a trustee, understand how a trustee is removed and what needs to happen pursuant to the terms of the document. Make sure that those fees are reasonable and documented, and then make sure that your trustee understands that they need to be as close to immediately responsive to requests for information as is reasonably possible. Even if it's just a, hey, got your request for information, can't get to it today. I expect to have it to you within 1 week or 2 weeks, whatever it is. Much the way that we talk to our clients when we get a request for information, the trustee needs to be talking to the beneficiaries just like that. And then, of course, be cognizant of those expenses. All right, I do want to spend a little bit of time with some beneficiary rights, if only to highlight, I think what happens a lot of times is that beneficiaries have a lot more rights than some trustees and potentially even some advisors really understand, and know. These are all the rights that are granted pursuant to the Uniform Trust Code. Likely, these rights exist in your state as well, and potentially even more. And so it is incumbent, again, upon us as the advisors that we understand and are advising our trustees of these beneficiary rights, to take them seriously and to be as responsive as we can. I've talked about a lot of these, so I'm not going to belabor the point. Just make sure that you understand you understand them, and that your trustee understands them. And this was actually my favorite place, was representing the beneficiaries, because it is much easier to say, "Hey, so and so, dear attorney, the trustee has a duty to do X, Y, and Z pursuant to Florida statute, blah, 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 and they have failed to do that. Please remedy this as soon as possible. If not, further legal action will be considered." You'd be surprised how quickly things change when you do that. Actually, one of my favorite clients was a beneficiary who found me, and I really helped immensely because I was able to hold the trustee's feet to the fire about distributions from the trust. So make sure that you understand those beneficiary rights, especially when you're representing a trustee. And finally, just one note before I move on to the next slide. There is the ability to waive rights to reports and rights to other information generally. It can be withdrawn. It is not absolute, and it can be withdrawn, and so understand what that looks like in your state. The things that can be waived, and how that waiver ultimately works, and how the withdrawal of that waiver works. I talked about representation a little bit earlier. I'm not gonna go over it again. You don't need me to read to you the different, how methods of representation. So next slide. Just one of the things okay. I just put this language on here because I think it's helpful for us as practitioners to help our clients use the right words when we're talking. And so we have inter vivos, trusts that were created during life, and testamentary, trusts that are created at death. Inter vivos can be revocable. And if we have revocable if we have revocable trusts, all of the rights, all of the duties, all of the everything that we've been talking about thus far flows to the settlor, full stop. So none of the beneficiaries who will take after the settlor's death have any rights whatsoever until such time as the settlor dies, period. So, because I think that that's also, and again, a little bit of a gray area when you end up with issues of incapacity, but just worth flagging the issue for you in your practice so that you take a look at your particular state statutes and understand, okay, while this trust is revocable, we don't need to worry about any of this stuff. If my settlor becomes incapacitated, how does that change? And what kinds of things do I need to be concerned with? I know that California has some unique rules. I'm not aware of any other states, but just, again, make sure that you as the practitioner understand where those rights go. Okay. Directed trusts. These have become increasingly common, and so I wanted to spend just a moment talking about the directed trust. They're becoming more and more common. I've been in a lot of conferences of late that talk about these and talk about how great they are, and I think that they have a place. I don't think that they are the end all be all. Of course, a very attorney answer to give. So, the place where I see kind of the most issue, the most friction, is this idea that a trustee believes that if they're following the directions that have been given, then they're insulated from liability, and that's not exactly true. So, under Uniform Trust Code Section 808, and look to see where it exists in your particular state's trust code, the person giving the direction, the trust advisor, generally is the one who has the fiduciary duty, but that doesn't absolve the trustee entirely. So just make sure that that is clear. Like, well, hey, the the director told me to do it, so I did it. There are some limitations there. And that's really, you just need to understand how that looks in your particular state, as long as the statutory, so the trustee doesn't have liability as long as the statutory standard that exists in your state has been followed. So it shifts, that directed trusts shift liability, sort of, but you have to make sure that there's no manifest breach of duty, fiduciary duty. So it's a very, there's a lot to that. I just wanted to highlight some of the issues that are a cause for misconception. So there's this misconception that if there is a directed trust and a trust director, a trust advisor, some states call it a trust protector, although there's other issues there, that if they are directing the trustee, that doesn't mean that your trustee should just forget about their own separate fiduciary duties and do whatever is directed. There is a duty that they still need to follow. You need to look to your state statutes and understand that. Okay, moving on. I'm gonna probably skip over some of the next slides just so that we can keep this moving. So what I've got is kind of understanding the role of the attorney and the paralegal and how the attorney plays in. Charging for the meeting, not charging, you can read those. Basically, the thought here is if they're a longstanding client, you probably don't need to charge. If they're not, maybe you want to, and then let it go as part of the overall bill. Deciding if it's the attorney or the paralegal. If it's a simple trust, probably maybe potentially a paralegal could handle it, depending. If it's a taxable trust or a taxable estate, then you want an attorney involved. Okay, paralegal checklists. A well-trained paralegal is your best risk management tool, full stop. I have seen amazing paralegals that sort of guide young attorneys, and so I absolutely love a well-trained paralegal, and I think that there are valid ways for the paralegal to really take some of the stress and burden off the attorneys. So these are kind of my personal steps for them. Again, I'm not gonna go through them. You can read them on your own. I have no problem making these slides available to you if you don't have access to them. Again, uh, the first meeting, we're gonna skip over a bunch of this stuff. You know how to run a meeting. If you don't, here's some tips and tricks for what you should ask the trustee to bring in order to make the meeting more productive. Again, this is not intended to be a end all be all. This is intended to be a helpful checklist. Hopefully you will take it and improve upon it, really and truly. I'm going to talk a little bit now about what do we really do? Because I've spent a lot of time talking about the duties and the responsibilities, but how do we really understand when we're the attorney who's running the administration, where do we start? Because sometimes knowing where to start is really a difficult issue. And so we start with actually just reviewing and understanding the trust. That is my favorite answer whenever I get asked a question. So I get asked that question a lot. Hey, where do I go? Well, let's start with the trust instrument itself. So that's number one. And then I think the rest of these kind of naturally flow from that. Gather the assets, secure the assets, value the assets. If we need to do a probate, let's do that probate proceeding. Let's think about any post-mortem strategies. Let's make sure we get those notices out to the beneficiaries, to the creditors. Are there tax elections that we could be making? If so, what's the timeline for that? Let's make sure that we have established a timeline for those. If there's an estate tax return that's due, let's make sure that we've established a timeline. The estate tax return, for those who don't know, is due 9 months after the date of death. There is an automatic 6-month extension, so you get up to 15 months before they're going to come looking for you. If we have any state documents that are due, let's make sure that we know that. Most of the time, the state follows the feds, although I believe there are some states that have a strict 9-month deadline without that additional 6-month automatic. So if you are, make sure that you know whether or not you're in one of those states. You're going to need to make specific devises. Your trustee might be asked to help with transferring non-trust assets. You're eventually going to need to fund subtrusts. We'll talk about those funding formulas in a bit. Think about accountings and then release and discharge. So overall, really what we need to be thinking about is that for those of you who regularly do probate administration, trust administration is probate for a trust. Full stop. You will never, ever get me to say otherwise. Again, the same steps. Whatever you would do in probate, you're just doing it, but you're doing it in the context of a trust. And generally speaking, without court oversight. That's the whole goal of the trust. Well, not all the time, but much of the time, we just want to avoid having to go talk to a judge over and over again every time we want to do something. One of the steps that I talk about is reviewing the trust agreement and really understanding the trust. Sorry, I got behind. So I am just in the interest of time, I'm not going to go over pecuniary versus formula. If you are at all unclear about any of that, please reach out to me. I'm happy to have a conversation or a little email back and forth with you, because that was something that I didn't really fully understand for much of my private practice. I had no idea what pecuniary versus fractional even meant. And, so there's pecuniary versus fractional. I hope now most of the time, most of you are seeing fractional in practice, because pecuniary can come up with some issues. You'll note on these slides, I've actually put what pecuniary looks like for you. So hopefully that can also help act as a little bit of a guide for you. And then when we're talking about funding a pecuniary bequest, there's two options: true worth versus fairly representative. Again, I've given you the language. I'm going to hop over keen and gain also, because in the interest of time, I've got about 17 minutes and we're not even halfway through my slides, or we just hit halfway. So again, fractional formula, the quick takeaway here that I tell all of my members to this day: if you are unsure whether you should be choosing pecuniary or fractional, choose fractional. You will never be committing malpractice. And that, I think, are just words to live by. In this day and age, there is no reason not to do a fractional formula. Now, there could be valid reasons for doing pecuniary, but I prefer fractional. I think most practitioners do as well. Okay, we are going to skip over some of this. What happens at the first death with what happens at the second death. We're going to skip over inventory and valuing assets. Again, just the things, I've got a lot of kind of useful information here. These are places where you can gather information. So, of course, you're going to I always ask for account statements for the last year, because you can determine a lot about what was happening in the trust from those account statements. So you want all of that. If there are any actual paper certificates here, if I were doing this in front of a live audience, I'd have you raise your hands if you've actually seen them. I have. They're fascinating. I love them. And they're quite pretty, actually, really. It's kind of sad to me that they're moving away from that. You want to be, if you have a business that is in the trust, you want to be extraordinarily careful with the business. You want to make sure that you fully understand what the trust specifically says should happen with respect to the business, whether or not it makes sense to continue the business, who the intended beneficiaries are, how it's going to run, whether it should continue to run. And I could do a whole talk about that. We're going to skip that. You want deeds and copies of mortgages for your real estate. If you have retirement plans that are run through the trust, you absolutely want to see if you can get your hands on those beneficiary designations. And again, that's a whole other presentation. Life insurance, you want to make sure that you have good information on that. You want copies of the gift tax returns, and you want income tax returns for the last 3 years. All of this information is going to provide you with a complete picture of the assets that belong in the trust, or maybe that the trustee thinks are in the trust but actually aren't in the trust. This is where you gather that information. On the next slide, I talk about appraisals. I'm not going to go through that here. They are they're an absolute necessity in a taxable estate situation, and they are quite helpful in non-taxable estates when you have certain issues with respect to the assets, hard to value assets, real estate, businesses, those types of things. Here's how you can get values for your stocks and bonds. Alternate valuation dates. So did I talk about that? Oh, yes. Okay, actually, I want to go back one slide, two slides. There are three important dates. I did want to touch on this, so forgive me for flipping back a little bit. There are three important dates when you're considering valuations. The first and most important is the date of death value for all of the assets. The second potentially important date is the alternate valuation date, which is 6 months after the date of death. It may or may not have ultimate importance, but still you want to make a note of it. That's a date on which you should value assets. And then finally, your date of distribution. These are the three dates that matter. The rest of the dates are not going to matter so much, but you want to make sure you know the value of the assets on these dates and that you're saving them someplace where you can refer back to them if required, if necessary. Okay, the alternate valuation date. So this, I said previously, this might matter. Here is why it only might matter. So the alternate valuation date says that in a situation where the value of the gross estate and the sum of the net estate and GST taxes, so both the value of the gross estate and the total sum of the taxes is a lesser amount than it was as of the date of death, then you can use the alternate valuation date as the date on which you're valuing the assets. Now, it rarely works in practice, particularly at the first death, because if the estate, and I mean estate as in total estate, including the trust, was appropriately structured in a married situation, you have zero taxes at the first death. So just if you don't remember anything else about alternate valuation, remember that it rarely has an impact at the first death because if the estate was properly structured, there shouldn't be taxes upon the first death. There may be, but those situations are rare, few and far between. All right, we are going to, I don't want to burn through taxes, but let me just see. Okay, good. So I've almost caught up to oh, good. All right, we're gonna take it back. We're gonna slow it down a little bit. So file the appropriate tax returns. Okay, what does that mean? The Form 706, any outstanding Form 709, the final Form 1040, and any Forms 1041. The Form 1040 is for while your decedent was alive. The Form 1041 happens the day after they die for your potentially estate. We're not talking about estates here, but still know that that exists. And also for your trust. Now, there is a 645 election that says that if we have an estate, our trust can piggyback onto the estate's Form 1041 and they can ride together. Why is that anything? Well, because a trust all by itself is stuck with a calendar year. But if you have an estate and the estate is using a fiscal year, your trust can then switch over and use that fiscal year. So it might have some impact. A good CPA will help walk you through that. Don't forget about state forms. A few other notes. So you should have a conversation with your trustee or whoever is going to be filing that final Form 1040, whether it makes sense to file it jointly or separately. That is an important conversation, and I don't want to understate its importance, but we do have to talk fast. I have to talk faster. Sorry. One of the things that you really need to be considering in this is the idea of joint and several liability and whether it makes sense to have your fiduciary continue to be jointly and severally liable for any taxes that might be due on that final Form 1040. And generally speaking, when it's married, it's a much better result for both parties if it is married jointly rather than married filing separately. The Form 706. So a lot of times at the first death, there isn't going to be a need to file it because, as we've discussed, you don't have a taxable situation, It could be important if you are funding subtrusts and you have concerns about basis, and so you want to document that some way, you wanna lock it in, you wanna get that moving. It also could be important with respect to electing portability. Again, something just if it's something that you are considering, you've got more time if you're filing for portability, but it's better to do it while everything's still fresh. A couple of notes on the next page, just for everybody's edification. Okay. Deductions can't be taken on both the Form 706 and the 1041. I hope that everybody knows that, lives it, loves it. Understand that if there's no estate tax paid on that Form 706, then it really doesn't make any sense to try and take any of the deductions for trust administration. Excuse me, expenses thereon, and funeral expenses can only be deducted on your 706. Okay. All right. Because this isn't specifically trust administration, I mean, it's related. We're going to skip over it uh, because we can talk about it later. So, one of the things that does probably make sense to spend a little bit of time left, well, here is portability versus division. So, if you are in a situation where you've got a disclaimer trust in front of you, and for those who don't know straight off the top of your head, the disclaimer trust says, hey, give everything to my surviving spouse. But in the event that my surviving spouse decides that they don't need it all for whatever reason, they can disclaim a certain portion of these assets, and those assets are going to go to a separate family trust. Most of the time, the surviving spouse is still going to be a beneficiary of that trust and still be entitled to probably income distributions, potentially distributions of principal, and maybe they'll have some other bells and whistles. They might have a limited power of appointment, all sorts of stuff. So the question becomes, do we leave everything to the surviving spouse and allow her to elect portability? And so we preserve the applicable exclusion amount that the decedent spouse had. Or do we say, you know what, surviving spouse, it makes more sense for you to disclaim right now and fund that family trust and use up a portion of the applicable exclusion amount, potentially all of it, with that family trust? And how does that look? And so on this slide and the slides that follow, I've listed out the advantages of portability and put the disadvantages of division. So portability, think everything's going to that surviving spouse. They're going to keep it all in their name, and they're going to port the decedent spouse's applicable exclusion amount, versus division, they're going to disclaim a certain amount that's going to go into a family trust, potentially also a marital trust or marital trust, I suppose. And what does that look like? And these are the disadvantages. On the next slide, we've got the continuing advantages of portability versus disadvantages of division. And then on the next slide, the advantages of division versus the disadvantages of portability, and then a second slide for that. I am going to skip over them because we are fast approaching the end of the hour, and I know that many of you have other commitments that you need to get to, and I do want to leave us a little bit of time for questions. So we're going through that faster than I wanted to. Okay, a few of the post-mortem strategies. These are the things I could talk all day about, many of these things, but we're not going to. So the things that you want to at least check off the box, the conversations that you are having with your trustee. Is this a situation where a disclaimer makes sense? Is there a way that we can better utilize a marital deduction? What are we doing with retirement assets? How are we addressing those? Can we do it in a better way? Is there a tax on any prior transfers? Do we have to worry about 2032 Cap A valuation issues? What about that alternate valuation date? We've talked about that. What about GST allocation? Is this a situation where modification or reformation of the trust is going to be valuable for whatever reason? Do we want to think about decanting? Does the trustee actually have sufficient powers to work into a decanting statute if my particular state has a decanting statute. And if we're going to go rogue or we're going to disavow somehow the terms of the trust, can we do it through a non-judicial settlement agreement? That's one of my favorite tools of the trade. The answer is maybe. So I've talked about modification, reformation. I've talked about decanting. Just know that, make sure that if you are considering decanting, number one, your state has a decanting statute, and not all states do. And then number two, that your trustee has sufficient powers under the terms of the trust instrument in order to avail him or herself of the decanting statute. If you don't have a decanting statute, there might be other ways that you can get there by looking at things like the trustor's domicile, the trustee's domicile, where the asset's located, and then change the domicile if there's a better decanting statute elsewhere. So all things that, and there might be other reasons to change domicile as well, but decanting is kind of the big, easy connect in my brain. Okay, final notes that I want to talk about. So I think I say in almost every presentation that I give, it's never the clients that I turned away that haunted me. It's the ones that I knew I should have turned away and ended up representing anyways that I regretted. And so I never regretted saying, you know what, this client isn't for me, but I often regretted more. I can think of probably 5 or 6 different times where I knew in the back of my head I shouldn't take this client, and I did, and it was nothing but a nightmare. And so there are here, these are sort of the hints for you, those red flags of, should I really be taking on this case or should I not? Are there disgruntled heirs? If this turns into litigation, is there someone in your office, and it could be you, who can handle the litigation, or am I going to need to refer it out? Does it already look like we are going to get litigation? And if so, do I really want to step into that? When I read this trust, and remember that was one of the first steps that I said way back when they first walk through the door, you better read that trust and understand it. Are there things that I don't get about this? Are there drafting errors? Are there ambiguities? Am I having questions already? And if so, how are we going to resolve that? Am I comfortable putting my license on the line by taking a certain position, or are we going to end up in court anyways? And go back to the next one, is that something I want to handle, or do I have somebody that I trust to refer it out to? When I'm reading that trust, did they talk about taxes? Is there a tax allocation clause? If so, do I understand it, and can I explain it to the beneficiaries? Aggregation of interest. So is this a situation where there are interests in the same asset in multiple different trusts? And is that going to cause a problem somehow? And then finally, has there already been follow-up, or excuse me, has there been a lack of follow-up either to financial institutions or the client, or as we're moving along, have I been following up to no avail? And so those are all just the kind of red flags. And then finally, the very last slide, these are the reasons that trustees get sued. I think there's 10, 2, 4, 6, 8, 10. There is. These are my top 10 reasons that trustees get sued. And then, so again, you don't need me to talk you through these. You are certainly capable of reading them yourself. And I think I've just hit the top of the hour. But I also want to make you aware in the slides that remain, and again, I don't need to talk you through those. There are several checklists that I've given you. Use these as a starting point. Uh, Expand upon them and let me know what other ways that you thought to make them better. If there's things that I miss, I didn't do that, but certainly just to be helpful for you. I see Nina is here. I think I hit my hour, so I'm going to open it up for questions. I see that I do have some, so I will start with the questions. So, what is the duty where the trustee is also the beneficiary or the sole beneficiary? David, that's a great question, and I should have been more clear about this. And somebody I think actually asked me this in the probate presentation that I did as well. So the duty runs to themselves. So in effect, they can do whatever they like. I always caution, though, there is one place where you do want to be careful. Hopefully, there is uh, what's the word I'm looking for? If we are the sole trustee of a trust, of which we are also the beneficiary, hopefully there is at the very least what I call the HEMS standard, which is, you'll find it all over in the code, health, education, maintenance, and support, in order to at least provide some small level of asset protection. And so you just want to make sure that if that's the case, you are documenting that these distributions are for health, education, maintenance, or support. That just helps protect. And again, I'm not saying that that asset protection is the end all be all. There are certainly, if a creditor falls into one of those categories, then it's going to be destroyed. And if the trustee doesn't abide by the terms of the trust, then you also run the risk of destroying that. So the duties, of course, run to themselves, but just something of which the trustee/beneficiary needs to be aware and advised. Make sure that you're following that. And then also, too, make sure that they're still taking care of the other kind of responsibilities with respect to filing final income tax return, filing that Form 706 if necessary, filing outstanding 709s, because they're on the hook for all of that stuff. So just make sure. Okay, we have, would it be appropriate to categorize the duties under two heads? The first being the general duties of care of the trustees, and the latter under the head of fiduciary duties, or would it be better to leave the duties isolated? So my I don't know that this is necessarily a better one way or the other. In my practice, listed each duty separately, full stop, because I wanted to be very clear with my trustees. You have a duty of impartiality. You have a duty of loyalty. You have a duty not to act for the benefit of the beneficiaries in accordance with the trust. I think I got it all. You have a duty of prudent administration. You have a duty not to segregate. And so I always kept them each very clear, because each duty exists in and of itself. And so if you're going to separate them into kind of the general duties and the fiduciary duties, do that. But I still think make sure to list them out, because I think otherwise you're doing a disservice, because it's just too, I think people get a little lazy, and it's very hard to remember constantly. You can't do that, because that potentially violates this. My favorite is when somebody is doing something not in accordance with your walk. When somebody is doing something not in accordance with the terms of the trust, that's a breach of that's the breach of the duty of administration. Full stop. That's a breach of fiduciary duties. The trust says to do this. If you're not doing it, you have breached your fiduciary duties under the trust. Now let's talk about why. What that means, is there a valid reason to take care of to do something in that way? I'm not saying it can't ever happen. I'm saying we need to have a legal reason, a legal methodology that doesn't breach the core fiduciary duties, the ones that are non-waivable, to do something. So that's where that non-judicial settlement agreement comes into place: trust modification, trust reformation, decanting, things like that. Nina, it looks like I'm all out of questions. I appreciate your whole Justia team, and thanks to all of the attendees. I hope that you learned something, took something away. And like I said, I remain, if you can feel free to reach out to me anytime. I love teaching. I love helping people learn. I had some great mentors, and this is me passing it forward.
Wonderful. Thank you so much, Trina, for your expertise and sharing that today. You can hop off if you have to go, but feel free to
Wonderful.
stay if you need. Thanks so
All
much.
right. Thank you. Take
Um,
care. Bye, everyone.
And thank you to all of our attendees for your questions and for being here today. We want to thank you all so much for joining us for another Justia webinar. For all of our lawyers here today, I also wanted to mention that we do have free CLE webinars through our Justia monthly free CLE webinars. Each month, we have a select webinar that is eligible for free CLE credit at no cost. To be eligible for those presentations and getting that CLE credit, you must have verified your law license through the Justia Lawyer Directory, attend those full sessions, and then complete a verification afterwards. If you are curious about what upcoming presentations are eligible for that, you can always visit freecle.justia.com. Thank you all so much for your time and have a wonderful rest of your day. Thanks so much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.